Well, good afternoon, ladies and gentlemen. Welcome to the sixth panel. My name is Wenqi. I'm the professor of international law from Renmin University of China. And I was before one of the prosecutors in the OTP of the ICTY and ICTR for more than 7 years. Of course, for me, that period of experience was just great. And because of that experience where I'm myself very much interested in the development of international criminal law. And for that reason, I'm really very grateful to the International Nuremberg Principal Academy to invite me to participate to this conference and also to invite me as moderator for this very important panel. And of course, this is a very good occasion because this chair marked the 17th anniversary of the delivery of the judgment of Tokyo trial. And I think it's very important for us to assess the importance and also the impact upon the development of international criminal law by the result of the Tokyo trial. And for this panel, of course, we are going to focus on the judgment and post-judgment development. That means we are going to see what immediately happened after the judgment delivered in November of 1948. And here, of course, there are some issues which are also very important, very interesting, such as clemency, pardon, and amnesty. What happened to these issues after the judgment. And besides, after the judgment by the Tokyo Tribunal, the domestic trials were also conducted in some of the countries, such as in Australia, in France, in the Netherlands, in UK, in the United States, and in China. And actually, in China twice, once by the national government of Chiang Kai-shek, and then that was in 1946. And then 10 years after, by the Communist Party power of China in 1956. So here again, also some questions might be very interesting. So what was the scope of the crimes covered in domestic trials? Of course, in the previous panels, we mentioned this already, someone suggests if we would like to look into the issues such as fairness or unfairness, and then we could do some comparison, etc., etc. Anyway, we are going to discuss about all that to see what kind of impact the Tokyo trial has brought to the development of international criminal law, by the judgment and post-judgment development. As to the procedure, we consulted each other, and then we prefer to do this way, firstly, each of the panelists will address to the audience. And after that, of course, it will be open to the audience for questions. And then after the questions and answers, and then each of the panelists will be also provided as opportunity to do the concluding remark, which will be very short, about the 2 minutes. So with all that, with your permission, we are going to begin our panel discussion. And for me, of course, I will be very delighted to introduce the first panelist, namely Professor Sandra Wilson. And Professor Sandra Wilson is a professor and academic chair of history at Monash University and fellow of the Asia Research Center. And she is also a specialist on modern Japan with a focus on Japanese society and politics in 1930s and 1940s. And as to the writing and publication, and she is the co-author with some of the others, of course, on Japanese war criminals, the politics of justice after World War II, which was published by the Columbia University in 2017. And she herself is also author of the book Manchuria Crisis and Japanese Society between 1931 and 1933. And she is right now working on the question of why the Japanese military committed war crimes in the Pacific between 1941 and 1945. And for the topic she's going to present today will be focused on clemency for war criminals convicted in the Tokyo trial. So with all that, and also with your permission, may I invite Professor Sandra Wilson to give the floor. Yeah, welcome.
Thank you for the kind introduction and for agreeing to chair our panel. I'd also like to thank the Nuremberg Principals Academy very much for inviting me to this wonderful occasion. Matthias mentioned this morning that it was a good idea to treat the Tokyo trials in historical perspective, and I'd like to also suggest that we need to go beyond the courtroom, that we can't understand the trials without also thinking about what came next. Broadly speaking, there are two ways of dealing with historical grievances, by which I mean the sense of injury for great wrongs that have been done to us, whoever we are, in the past. One way is to insist on a kind of permanent punishment, or at least permanent acknowledgement of guilt. And the other way is to assert that perpetual antagonism is not productive in the end, and to allow for the possibility of drawing a line in the sand and saying enough is enough. These two choices also apply to the punishment of very serious crimes, including war crimes. One way is to insist on abiding by the sentence as it was passed by the court, because we have to respect the victims of the crimes and the sanctity of the law, and we need to protect society. The other is to allow for the possibility of clemency. That is, the granting of concessions to convicted prisoners, especially by shortening their sentences or letting them out on some kind of conditional or early release. In 1948, when the verdicts were handed down in Tokyo, everyone was on the side of maintaining the rage. There was no one that I've found thinking about the possibility of early release for the IMTFE prisoners. 20-year terms were supposed to last for 20 years and life terms were supposed to last for life. In late 1952, of the 25 men who'd been convicted at Tokyo, 12 were still alive and still in prison. Of the others, 7 had been executed, 5 had died in prison, and one, Shigemitsu Mamoru, who got the 7-year sentence, had been let out on parole by the American military authorities. The remaining 12 prisoners all had life terms, and they were supposed to stay in prison for the rest of their lives. But they didn't, and they didn't stay in prison for very much longer, just as the German war criminals also didn't in a parallel process. Over the next 3 or 4 years, gradually, the governments that had convicted them collectively decided that it was no longer the most productive way to maintain permanent antagonism. The last of the war criminals convicted at the IMTFE was released in early 1956. That's only a little over 7 years after he was convicted. The story of how these men were released, meaning how and why clemency was exercised, hasn't attracted much attention in the scholarly literature. I think it's because it seemed to be about politics and not law. That's my current theory anyway. When clemency is mentioned, it tends to be regarded as a sign of weakness among the Allied powers, of giving in to Japan, sometimes of a betrayal of the victims of Japanese war crimes. Or recognising that Cold War politics was important in this process, clemency can be interpreted in some quarters as a sign that politics interfered in the workings of the law and thwarted the intentions of the lawmakers and the prosecutors. Sort of dirty politics getting in the way of the clean law. In fact, the granting of clemency to the war criminals convicted in Tokyo was neither of these things. Above all, it was a normal bureaucratic impulse, and it was supported by, that normal bureaucratic impulse was supported by political considerations that were particular to the war crimes trials. In all or most justice systems, we can see that sentences are altered, usually reduced, after they've been passed down. Variations to sentences take different forms in different places, and they're granted for different reasons. They might be individual pardons or general amnesties. It could be through a system of parole, that is a form of conditional release after a certain period, or commutation of a death sentence, or outright reduction in the length of time to be served. All of these variations can be classed as forms of clemency. At the time that we're talking about, clemency existed in several forms in the home countries of the governments that prosecuted Japanese war criminals, and so they had already become more or less normal for many officials. Once the doors closed on the war criminals who got verdicts at Tokyo, relatively routine and familiar procedures took over. They had committed extraordinary crimes, but once they were in jail, things got a whole lot more ordinary in a lot of ways. Allied governments still remained committed to making war criminals accountable for their offences and to upholding the validity of the original trials and to keeping faith with victims. All those things remained important. And some officials and bureaucrats never did really accept clemency because they thought that war criminals were dangerous or that their own domestic constituencies demanded continued vengeance, for example. But on the whole, Allied governments were increasingly convinced that Japan, along with Germany, had to be incorporated unequivocally into the Western camp in the worldwide struggle against communism, and they recognised that if the governments of the two countries were going to be persuaded to take on weighty new global responsibilities, the wartime allies couldn't keep treating them as former enemies. They would have to make concessions on a number of issues, and one of them was war criminals. These pressures only increased as time went on. Meanwhile, by the time the Tokyo trial verdicts were handed down, many Japanese defendants had already been convicted in the national tribunals and had been imprisoned. Allied governments were already actively considering ways of releasing and rehabilitating them. So when I said everyone was maintaining the rage when the verdicts were handed down, that went for the IMTFE prisoners. They were already sorting out how to let the others out who had already been convicted in the national tribunals. By the time the Allied occupation of Japan ended in April 1952, clemency for Japanese war criminals, like clemency for German war criminals, had become very much the bureaucratic norm. Of all the governments that had convicted Japanese war criminals in the loosely coordinated Allied system, only the Australian and the Filipino governments had not introduced sentence reduction or parole by this stage. That's April 1952. The steady release of Japanese war criminals had been possible for two reasons up to then. First, although prisoners in the national tribunals had been convicted in about 50 courtrooms across the Asia-Pacific region, they had been increasingly concentrated in one prison, Sugamo Prison in Tokyo. Some of them started off there if they'd been convicted in Japan, but over time, from 1949 onwards, the other prosecuting powers started to find it more convenient to ship the prisoners they'd convicted to Japan to serve out their sentences rather than keeping them in other jails in the region. The second factor was once they were transferred to occupied Japan, all war criminals still serving sentences were governed by one authority, that is the US military, because the US military ran Sugamo Prison. It didn't matter which government had convicted them. So all decisions on war criminals in Sugamo were made by one authority, the American military, which was free to decide whatever it liked on a unilateral basis. And it introduced a parole system. But in 1952, the situation changed dramatically. Article 11 of the San Francisco Peace Treaty stipulated that decisions on the sentences of war criminals convicted in national military tribunals would not rest with the Japanese government, even though sovereignty was being restored, but after this would be made by the prosecuting government on the recommendation of Japan. In the case of the IMTFE, variations of sentences would be decided by a majority of the governments that had participated in the Tokyo trial and had subsequently ratified the peace treaty. So these countries, there turned out to be 8 of them in the end, reviewed the IMTFE sentences jointly in a series of meetings in Washington, DC. So they had to work out how to make joint decisions about this. And in this circumstance, there was a great deal of scope for disagreement. By 1956, the issue of war criminals had rather severely tested the solidarity of these wartime allies. Trying to work out what to do with the IMTFE prisoners gave rise to Cold War rivalries and other international tensions that were sharply revealed in these discussions. Overall, the big picture is that the Allied governments showed an increasing desire to free the prisoners, but they weren't willing to take any action that might impugn the validity of the trials or that might seem to display weakness in relation to Japanese war crimes. And reconciling these two imperatives was a pretty tricky balancing act. The discussions over the sentences revealed 2 things, I think. First of all, negotiations over clemency didn't take place in a vacuum, and they couldn't be separated from broader issues. The Allied powers were jostling for position in relation to each other in the post-World War world, and arguments about what to do with the prisoners pretty easily got entangled with questions of international politics and international status that at times were remote from Japanese war crimes or Japanese war criminals, had nothing to do with them actually. Second, the governments showed a growing disinclination to antagonise Japan, in a really startling contrast with where they'd been just a few years before, and a marked attempt to avoid being singled out as a country that was particularly vengeful. Many difficult discussions about whether and how to release the prisoners took place, but before long one solution emerged which was really good from everyone's point of view. Applications for parole by the Japanese government routinely emphasised the age and infirmity of the prisoners. It wasn't hard to do because 3 of them were aged over 70 in 1952. Early in 1954, the 8 governments agreed unanimously to grant what was called special medical parole to the oldest one of them. It was Minami Jiro. He was nearly 80 and he was thought to be at death's door. The prospect of a death in prison, especially of an elderly or infirm prisoner, was extremely unpalatable by this stage to all the governments because it would make the prosecuting power look especially heartless and vengeful. So they freed Minami really quickly and he proceeded to live for another 2 years. 4 other prisoners were also eventually released on the same basis. All of them survived for some period afterwards, a couple of them for quite long periods. But in cases where special medical parole couldn't be used, it was very difficult for these 8 reviewing powers to agree on release. Initially, half the group favoured early release and half didn't, and so there was obviously a stalemate. But then things moved very rapidly in 1955 and 1956. The Australian government had been notorious for its hard line on Japanese war criminals, and it abruptly introduced a parole system for the prisoners in 1955. The British soon followed suit. The parole was carefully calculated. It was after 10 years, but you could backdate it to time of first arrest as a suspect or whatever, and it meant that they were going to be out very soon. The British soon followed suit. Then in Washington, the representatives of the relevant governments agreed, after these eventualities, to the parole of the remaining 7 prisoners, and the last was released on the 31st of March 1956. I think what was happening was that during the 4 years of deliberation over the fate of the prisoners, the balance of the relationship between Japan and its former enemies was changing significantly and very rapidly. The demands of the new Cold War and the normalisation of relations between Japan and other countries more generally had trumped any remaining Allied desire for vengeance against Japan for the previous war, this desire that had seemed so strong not so long before. Japanese leaders who came, after all, from the same ruling class as the IMTFE prisoners, and in some cases were pretty closely connected with them, had shown increasing confidence in making demands for their release and increasing power to do so, and implicitly when they did so they were rejecting the grounds on which those prisoners had been released in the first place. The Allied method of dealing with war criminals convicted at the IMTFE was much more cumbersome than the arrangements for dealing with prisoners convicted in national tribunals because the fate of those latter prisoners in the national tribunals was decided by single governments. It wasn't as simple as all that in practice, but a single government could decide what to do with the prisoner. But the result was the same in both processes. As at 31st of July 1956, 4 months after the last IMTFE prisoner left Sugamo, there were only 222 prisoners left in Sugamo at all. So these were people who'd been convicted in the national tribunals. There were no longer any imprisoned overseas except for a very small number in China. Most of the prisoners convicted in the People's Republic of China came back in 1956. 3 or 4 remained until 1964. The last Japanese war criminals left Sugamo in May 1958. So despite all the Allied rhetoric about the exceptional nature of Japan's war crimes, which we're all familiar with, relatively normal administrative arrangements, I'd argue, had overtaken the justice process. The politics of dealing with war criminals and the workings of bureaucracy had pointed in the same direction, and they reinforced each other. Japan's re-emergence in the international scene in the 1950s, along with this general administrative impulse towards clemency for imprisoned criminals of all types, had brought an end to the long process of Allied reckoning with Japan's leaders and with ordinary military personnel as well for their part in the disastrous war in the Asia-Pacific region. Thank you.
Thank you very much, Professor Sandra Wilson. And next speaker will be Dr. Narelle Morris. And Dr. Narelle Morris is senior lecturer in the Curtin Law School, Curtin University, and honorary research fellow in the Asia Pacific Center for Military Law, Melbourne Law School. And she is also the principal legal research on the project, Australia's post-World War II crimes trial of the Japanese, a systematic and comprehensive law report series. And she holds an Australian research for monograph on the Australian war crimes investigation and jurist Sir William Flood Webb. And she is also the author of the forthcoming Australia's war crimes investigation and prosecutions arising out of the Pacific threat of World War II, on a comprehensive guide to the Commonwealth record. And then when the topic she's going to present today will be focused on constructing the historical legacy of the International Military Tribunal for the Far East. So you have the floor. Welcome. Yeah.
So the Dean of my law school went over east in Australia last year and was discussing the research of his staff and mentioned that a wonderful young researcher of his school was studying Sir William Webb, and his conversational partner said, "Oh, the rude, incompetent one." So I'd really like to thank the International Nuremberg Principals Academy for inviting me somewhere where some people have said very nice things about Sir William Webb for a change. So in the last 2 decades, scholars in law and history have taken up the task of analysing and reassessing the IMTFE. What really remains to be studied in the English language scholarship, however, at least from my point of view, is what impact the judges and then scholars have had afterwards in shaping and constructing certain historical legacies of the trial. Of the judges, Rowling and Powell chose to remain engaged with the legacy of the trial and created opportunities to be best remembered. Both judges remain very public figures, Powell especially so in Japan, and both judges gave speeches and interviews and published their thoughts. Rowling, in fact, published hundreds of works, many of which mention the IMTFE. In addition to public exposure, the length of time that the judges had to contribute to the IMTFE's legacy varied enormously. Rowling had significantly more opportunity to shape the historical legacy of the tribunal than, say, Northcroft, who died in 1953, only 5 years after the trial had concluded. While many topics could be assessed through their historiographical development in the literature on the tribunal, the topic that does interest me is perceptions of the judges, particularly how certain observations of them came to be made, what evidence there is for them, and the subsequent trajectory of these observations through the literature. As James Sedgwick has pointed out, the overbearing caricature of the Australian judge and president, Sir William Webb, is so entrenched in the historiography that it is rarely questioned, let alone explained. And what is also rarely questioned, let alone explained, is the radical difference between the overbearing caricature attributed to Webb in Japan and how Webb was and is characterised as a judge in Australia. Webb's judicial character is overwhelmingly described in terms of his dignity, courtesy, humility and graciousness, characteristics which are completely at odds with the dominant view of Webb as judge in Tokyo. Now, some observations about Webb's performance at the tribunal do have to be made at the outset. Being president of that tribunal was no easy job, which critics seemed very willing to overlook when piling on the criticism. And of course, it was a job that worsened over time as the trial dragged on. So for those of you who are in the room who are legally trained, please put up your hand if, with full hindsight knowledge of what the tribunal was like, if you would take on the job as president of the tribunal. I think I probably could stop there, but I won't. So Webb was very well aware of the difficult tasks that he faced in holding together a very large number of very diverse judges. And we've had some calls this past few days about there should have been more inclusivity. Well, imagine if we'd had 15 judges or 20 judges. Okay, let's just stop there. It is fair to say that Webb did not receive the support he might have expected from the British Commonwealth judges, particularly Patrick, Northcroft and McDougall. Instead, they actively maligned Webb to their governments and sidelined him from the development of the majority judgment. He knew that he was sometimes not in the best frame of mind, and he told his wife, Lady Webb, "Frequently I am in a tempestuous emotional condition, which is a very bad thing for the president of any court." After the trial, criticism of Webb's character and performance starts emerging in the scholarly secondary sources in the 1950s, often drawing upon the critical opinions of those like Defence Counsel Owen Cunningham, part of the group that Diane Orentlicker mentioned yesterday, who were very quick to publish their critical views of the trial. Illinois trial lawyer John Allen Appleman was one of the first in 1954 to publish a substantial piece on the trial that specifically discussed judicial conduct. Appleman is very critical of Webb, but there are several key problems with his analysis, and as a result, those problems have flowed on into subsequent scholarly work, including by Minear, who uses him as a principal source, John Dower, and many others who appear to have accepted Appleman's views rather uncritically. Appleman's overall conclusion about Webb, for instance, was that there was definitely observed a tendency of the presiding Justice Webb to be autocratic and overbearing in his manner. And he went on to say that the attitude of the president was not one consistent with the standards commonly observed in the United States. And he talked about the ethical conduct and duty, courtesy towards the court, and said, I quote, "The court is considered to have an equal duty towards counsel practising before it. Arrogance on the part of the court by reason of its exalted position is considered in this country to be a violation of judicial ethics and an indication of the weakness of the man presiding. If this is used as a test of the competence of the tribunal in question, it leaves one with marked distaste for the judicial tactics employed. The insults to defence counsel were frequent." Now, the key problem with this analysis is that Appleman is holding up the United States' judicial style and etiquette as the norm, with no recognition that the IMTFE was not an American court, no matter what people say, was not being presided over by an American judge, and with no recognition that the judicial style and etiquette do differ from country to country. There are significant differences between expectations in the United States and Australia, for example, and certainly there is in British and Australian common law, and probably in New Zealand and Canadian common law too, no equal duty of judges towards counsel. Now, of course, insults from the bench to counsel or witnesses would breach judicial ethics, but there is an enormous difference between inappropriate judicial behaviour which does breach ethics and a judge's privilege and duty to control his or her court as he or she thinks appropriate in the circumstances. The latter may not be liked by the parties, and usually isn't, but it is a necessary part of controlling a court and being a judge. And as Webb wrote at the time, "If I was less firm than I am, they," meaning the defence counsel, "would take possession." Now, as well as trying to hold the tribunal to an American standard that did not apply, Appelman's examples of Webb's supposed arrogant and insulting behaviour mostly come from the early months of the trial, where Webb would have been engaged in his duty to shape the conduct of the trial, and in any event, when you look at them, are fairly poorly characterised as arrogant and insulting. Now, for instance, Appelman described an exchange when Captain George Furness for the defence characterised Dr. Kiyose Ichiro's earlier presentation for the defence as brilliant. Appelman reports that Webb, quote, abruptly told him to omit the compliments. But what Webb actually says is, I think you can omit the compliments. It is quite unnecessary. Now, the giving of an opinion like this is hardly arrogant or an insult to the defence. The day before, in fact, Webb has similarly criticised prosecutor Joseph Keenan for presenting rhetorical remarks at this juncture. And of course, it's a rather notorious 135-word sentence waffling on about expectations of the trial, and you can see that he criticises him equally. Now, that Webb was direct, short, brusque, acerbic, tetchy, spoke with asperity, or was sarcastic on occasion, and I've borrowed those from some of the adjectives and adverbs that people have used about him, it is undoubted. And as some of his judicial colleagues believed, and as Tutani has pointed out, these traits were neither helpful nor likeable. But when Appelman's examples of Webb's supposed behaviour are reviewed in the context of what was happening in the trial, and from an understanding of the necessity of any judicial bench to control a trial, they simply do not amount to arrogance or insults. Curiously, Appelman does not raise the infamous most stupid witness comment ever that Webb made in September 1947, which I think shows that his research with the transcript was also very selective. But that comment, the most stupid witness ever, that Webb made, was not an offhand remark that he just made one afternoon from the bench. It came after considerable aggravating provocation from Yonai, which drags out for pages in the transcript and is very clearly equally frustrating the prosecutor. Now, if you are not willing to accept that at least some of the criticism of Webb's remarks from the bench have been overblown by people like Appelman, who are perhaps misunderstood about what's acceptable in a court or misjudge what is acceptable, then let me give a simpler example of where Appelman seems to be deliberately casting blame upon Webb. And he is perhaps in this manner the start of the queue of critics who line up to make Webb the scapegoat for speaking for the bench, for having the only microphone, so as I currently do, or for the IMTFE generally because he was the figurehead. Now, given that everyone was suffering in the Tokyo summer heat in an enclosed courtroom under the filming lights, and Enrique spoke yesterday about what it was like in this room with the windows closed and the Klieg lights on, everyone was suffering in that heat in Tokyo, including well before summer had actually hit, and this was remarked upon by the judges, by the accused, by observers. And Appelman seems quite churlish to pronounce in 1954, therefore, that, quote, the president of the tribunal seemed much more concerned about his personal comfort than the conduct of the case. He complained bitterly of the heat, even adjourning court on that account. Now, as the transcript very clearly shows, it was for the reason of properly conducting the case that the trial was adjourned. And if the decision was not, in fact, unanimous amongst the judges, which we don't know, it was certainly not a decision made by Webb in a fit of pique. Now, while it might seem that I'm unduly focusing my attention on this deceased, rather hapless Illinois trial lawyer, the problem is that Minea relied upon Appelman very strongly to make an enduring contribution to the characterisation of Webb, whom he noted he had criticised sharply but was not seeking to scapegoat. And I'd certainly agree with the first comment there, but also disagree with the second. I think he did make Webb a scapegoat. And of course, many other scholars have relied upon Minea, including John Dower and many others, and have never actually dug back into some of the transcript or given it much thought, or not seemingly so. They've done so without considering what, if any, regard was given to the context and what, if any, evidence lay behind these earlier analyses. There are far too few scholars, both historians and lawyers, none of which are present in this room, who have actually read the transcript. Sorry, I meant to say all of us have read the transcript. Of course, it's the people not in this room that tend to fall into that category. And of course, access to transcript now is no longer precluded. We have no excuse now for relying upon Minea, Appelman, or anyone else to make these very important judgments. We need to go back to the transcript. So what I strongly believe is needed is a fresh start to research on the judges, which some thoughtful scholars, including many in this room, are engaged in. And in conjunction with this fresh start, we need less repetition of the cliches and the stereotypes, many of which are only relying upon previous sources. Instead, we need more original research on the judges. We need more consideration of the context, and we certainly need more consideration of whether sufficient evidence can be found to support a conclusion, particularly a negative one about judicial performance. Thank you.
Well, thank you very much, Dr. Maurice, for your presentation. And then the next one will be Dr. Valentina Plulina. And she is a PhD at the Cluster of Excellency Asia and Europe in a global context at Heidelberg University, a beautiful place, where she studied Soviet war crimes trial at Khabarovsk and the question of prosecuting biological warfare after World War II. And she holds an MA in International Relations from Kiev State University and in Peace and Conflict Studies from Melbourne University. She taught in the Russian Asian Studies Department of the Ludwig Maximilian University of Munich. And currently, where she's working at the magazine, this is Dutch difficult for me, where I try, anyway, in Washington, D.C. I'm not confident so I think I should. The topic she's going to present will be the Soviet riposte to the Tokyo trial, the Khabarovsk trial, and the Japanese biological warfare. So please welcome. Yeah.
Thank you, the Nuremberg Principals Academy, for inviting me here. It's a big honor to speak today in this historic room. I'm going to talk today about a largely forgotten Soviet war crimes trial that was set as a corrective trial to the Tokyo Tribunal. Despite the fact that the Tokyo Tribunal was regarded in the Soviet Union as an important historical precedent, the Soviets considered it to be inadequate for two main reasons. It's rather lukewarm findings of crimes against humanity against the Soviet Union, and also its inability to prosecute the Japanese biological warfare program. And in order to correct the flaws of the IMTFE, the Soviet authorities opened a trial of 12 Japanese citizens accused of planning biological warfare and experimenting on human beings without their consent on December 25, 1949, in the Russian far eastern city of Khabarovsk, right on the border with Manchuria. The Khabarovsk trial was convened after the global wave of war crimes trials was mainly over, and more than 4 years after the defendants had been taken prisoner, and also about a year after the International Military Tribunal for the Far East had finished its work. But before I move on to the trial itself, I would like to address to address the Japanese biological warfare program. We heard more about it yesterday. I will just give a couple of additional facts. So during the years leading up to World War II and throughout the war, Japanese military and civilian medical personnel conducted organized, structured, systematic experiments on human subjects. These crimes, which caused the death of several 100,000 individuals, were part of official Japanese government policy, beginning as early as 1930 and lasting until the Japanese surrender in August 1945. atrocities performed by the Imperial Japanese doctors can be classified in three main categories. First of all, research, which includes experiments on humans and mass production of pathogens. Secondly, training of army surgeons, during which living human beings were used as guinea pigs in order to train future surgeons. And thirdly, biological warfare tests that were carried mainly in China and on a smaller scale on the border with the Soviet Union. As it was said yesterday, the biggest and most modern research facility of the time was situated in Pinfan. It's a village of Pinfan near Harbin, and it was called Unit 731, which was officially established in 1936. Just showed him, like, I marked the Harbin, and Pinfan facility was close to it, and the SAR is Khabarovsk. So you can see how close it was to the place where the crimes, many of the crimes were committed. But I also wanted to ask that they were not committed only in Harbin, but all over China and also in other parts of Asia. It was a big program which involved not only Unit 731, but also other facilities. The Khabarovsk trial was perceived outside of the Soviet Union, especially in the West, as yet another Stalinist show trial modeled on the infamous Moscow Purge trials of the 1930s. The lack of any prior announcement of the trial, the exclusion of international observers, and strong propaganda elements all made it easier to dismiss the findings of the Khabarovsk trial and brand it as mere propaganda or show trial. The central message of the trial was to praise the leading role of the Soviet Union in defeating Japan and thus rescuing the world from an inevitable biological war. And it should be noted that this message was directed not only at Soviet citizens, but rather at the enemy in the beginning Cold War, the United States of America, who kept shielding many criminals who were involved in this biological warfare from prosecution, and as well as at the ally to come in the Cold War, the People's Republic of China, at least in the early Cold War. Moreover, Moscow used this trial and propaganda campaign related to the trial after it had finished its work to repeatedly address the Soviet participation in the Pacific War with a goal to legitimize their military actions in Manchuria in August 1945 and branded it as a prevention of a Japanese attack. The development of bacteriological warfare was presented as means of aggression against the Soviet Union. But despite all these drawbacks of the Soviet bacteriological trial, there were remarkable differences between the Stalinist purge trials and this trial. Unlike the purge trials, which were usually based on fabricated evidence, the evidence presented at the Khabarovsk trial has been largely collaborated with time. And there was simply no need for the Soviets to concoct evidence. The reality was horrendous enough. By combining elements of a show trial with truthful facts about Japanese medicine-related atrocities, the Soviet leadership strived to legitimize the trial. 12 defendants at the Khabarovsk trial were charged with committing crimes punishable under Article 1 of the decree of the Presidium of the Soviet Supreme Soviet of April 19, 1943. This decree was already well known as the legal basis of Soviet domestic war crimes trials of Nazi perpetrators and Soviet collaborators. The full text of the decree was not published at the time, and neither the accused nor their defense lawyers knew what this decree actually contained. And moreover, because this decree had been drafted several years prior to the Nuremberg and Tokyo trials, it didn't contain any specific reference to the substantive charges of crimes against humanity, crimes against peace, or even war crimes. The decree was originally designed to facilitate the trial and punishment of European perpetrators and local collaborators. And it was applied to the Japanese defendants by way of analogy. The Japanese had committed similar crimes to Germans and thus were liable under the same legal basis. So the prosecutor in Tokyo, Lev Smirnov, even compared the Japanese biological warfare trials and experiment with experiments conducted by German doctors in extermination camps. And finally, the decree was obviously created with the aim of prosecuting crimes against Soviet citizens committed on the Soviet territory. And the prosecution emphasized the planning aspect of the Japanese biological warfare program and warfare. It also urged that Japanese had committed crimes on Soviet territory by claiming cases of bacteriological sabotage on the border with the Soviet Union. While the Soviets did not manage to catch the most senior figures in the biological warfare program, they were able to round up a heterogeneous group of others connected one way or another with the Kwantung Army's Unit 731 and Unit 100. They included one high-ranking figure, Yamada Otozo, former commander-in-chief of the Kwantung Army, also senior administrators, various managers, bacteriologists, physicians, veterinarians, etc. All of the defendants pleaded guilty to the charges. And while the prosecutor's approach was predictable enough, the defense played an equally, even if not more important role in supporting the rhetoric of the prosecutor. Despite this assumption that defense lawyers didn't play a role in Soviet trials, the Khabarovsk trial shows that it's not entirely true. They identified their clients as the small fry in the conspiracy, and by no coincidence, the big fish, the organizers and instigators, happened to be the very people that the Americans kept shielding from prosecution. Moreover, the defense team and even the accused themselves added to the list of crimes set out in the indictment. Two lawyers considered that their respective clients, Takahashi Takatsu and Karasawa Tomio, had committed crimes against humanity. And two of the defendants, Kawashima Kyoshi and Sato Shunji, themselves admitted they had committed a crime against humanity. The frequency of the references to this crime, which didn't appear on the Khabarovsk charges, strongly suggests that the Soviets wished to establish a precedent for crimes against humanity charges because they were contemplating further allegations against senior Japanese figures. The tribunal found all 12 defendants guilty. 4 more senior figures received 25 years in the labor camp, and the last was sentenced to different terms ranging from 10 to 20 years, and the most low-ranking defendants were given 2 and 3 years of prison camp. But one notable feature of this sentencing was that the prosecutors had demanded the most harsh punishment possible. But judges had some space to maneuver and handed down marginally lighter sentences that were asked by the prosecution. It was a clear break from the unstated but almost universally observed practice at the time in the Soviet Union. The accused were also among the last to be spared capital punishment because the Soviet Union was to introduce death sentences in January 1950. So the prosecutors and the judges were in a rush to finish the trial by the end of 1949 in order to spare the defendants because they were too valuable as a source of information about the Japanese biological warfare program. So in this regard, they were not that much different from the Americans. In order to conclude, I would like to say that by February 1st, 1950, represented the culmination of the Khabarovsk project. That day, the Soviet ambassador in Washington, Alexander Panyushkin, handed a diplomatic note to the US Secretary of State, Dean Acheson, which proposed the establishment of an international criminal court to try as war criminals the Emperor of Japan, and 4 senior generals involved in the Japanese biological warfare program. Needless to say, the Kremlin offered to put at the disposal of the future trial all of the findings of the Khabarovsk trial. And this note attended a lot of attention, for instance, in the Soviet Union, in the United States, in Japan, and in China. But Acheson, ascribing devious Cold War motives to the Soviets, declined to respond. Even being just wanted to show you a couple of examples of propaganda campaign, which I just mentioned, and responses to the Khabarovsk trial, not just in the Soviet Union, but also abroad. Maybe if time allows during the discussion, we can come back to the propaganda aspect. But in order to conclude, I would like to point out that even being experienced in organizing numerous public war crimes trials, and taking part in international war crimes trial in Nuremberg and in Tokyo, the Kremlin was yet not able to foresee and address the critical questions that inevitably arose with regard to the Khabarovsk trial. The new geopolitical situation, too, had its impact on public reactions to the trial in the countries that once sailed in the same boat under the veil of bringing justice for war crimes. The Cold War was a reality of the post-war world, and Allied unity that had existed in the face of a common enemy was already a thing of the past. Thank you.
Thank you very much, Dr. Valentina Plunina, for your presentation. And the next one, and also the last one of this panel, will be Dr. Franziska SERAPHIM. And Dr. Franziska SERAPHIM is Associate Professor of History at Boston College and author of The War Memory and Social Politics in Japan in the period of 1945 to 2005, and which was published by Harvard 2006. Her research on public memory, historic justice, and social movement in Asia in comparative and global perspective has been supported by the Japan Foundation and some of the other institutions. And her recent publications include Carceral Geographies of Japan's Vanished Empire, War Criminal Prisons in Asia, and the Dismantling of the Japanese Empire in East Asia, and a penologic program for Japanese and German war criminals after World War II. And her recent book, manuscript, is entitled Geographies of Justice in Japan, Germany, and Allied War Crimes Program. And today, the topic she's going to present will be losers' justice, where so far we talked quite a lot about the victors' justice. So right now we're coming out losers' justice. Well, what is it? We are going to listen to her. Well, thank you, welcome.
Thank you very much for this gracious introduction, and thank you for this wonderful conference. I'm so honored and grateful to be part of it. So many of you have actually laid the ground for what I'm going to say, even though I feel I'm stepping aside in some ways from the international criminal law that is the center of the conference. And yet, you know, the importance of the Class BC trials that Robert Cribb has mentioned, Matthias Sachmann's emphasis on the historical context that we really need to take into consideration, and of course, Sandra Wilson's talk on this panel on clemency that paints the immediate context for my few comments. But also I wanted to mention quickly Valentina's wonderful presentation on one tribunal that tried to correct Tokyo in certain ways. I just wanted to mention, maybe this will come up in discussion or so, that there have been other such attempts, not least of which was the Women's International Tribunal of December 2000 in Tokyo. That was not an official tribunal in that sense, but that was convened by three major civic organizations led by women in Japan, in Korea, and in the Philippines. And I think we should give some space to alternative ways of coming to terms with what was neglected in Tokyo. And in that particular tribunal, sexual slavery and the emperor's responsibility were looked upon, and very much by inviting, on a voluntary basis, major judges from the ICC. So the global international criminal law community was very much part of this effort. But let me return to what I'm perhaps provocatively entitling loser's justice. I have no intention to belabor the problematic concept of victor's justice. I think we've put that on the table well. In fact, perhaps the most radical reevaluation of victor's justice is to insist on its very literal meaning. To not engage with its political uses, but to simply acknowledge that the victors sat in judgment, which they clearly did. This shines the light not on the legal tools used, but on the power political context that conditioned the Allied trials in both Europe and Asia on a very basic level. I'm not ignoring the political debates, I'm putting them aside in order to shine the light on something that is often missed when we look solely through that lens. So I beg the patience of all the legal specialists in this room to listen to the concerns of a social historian. Moreover, despite the fact that our entire conference is focused on the objectives, intentions, and mechanisms of those who sat in judgment, allow me to explore, if only for 10 minutes, the ways in which Japanese and Germans engaged an Allied program over which they had no control in the legal sense. They couldn't overturn sentences. And yet, and this is true in both Japan and Germany, they were able to transform, in a sense, the Allied war crimes program from a matter of criminal responsibility, the intention of the victors, into a tool of social integration and political rehabilitation, namely the social needs of the losers. There's an important parallel story here between Germany and Japan, embedded in significantly different domestic and international political contexts. We need to carefully disaggregate these layers of social political history, to which the experience of defeat and the responsibility of rebuilding a legitimate state within the constraints and also the opportunities afforded by the occupying powers were absolutely central, albeit in very different ways. This post-judgment story has implications for broader understandings of transitional justice mechanisms, but it is hampered by a mythology that emerged in the 1990s, in which Germans appeared morally committed to mea culpa, while Japanese were said to be constrained by a unique culture of forgetting and irresponsibility. It colors what aspect of early post-war efforts to address the criminal past are seen, how they are interpreted, and in what part of the world. It's always striking to me where I give my talks. When I talk to an audience at Harvard of Japan scholars, they are absolutely fascinated with what I have to say on Germany. When I'm here, everybody yawns because they know that part. So it's quite striking how divergent this is. German historians' critical investigation of heretofore neglected arenas of German post-war irresponsibility or responsibility, both in relation to the Communist East, as Annette Wenq's work shows, and the amnesty laws for Nazi perpetrators under Adenauer in the West, Norbert Frey's work, these works are not heard in Asia, where the complexity of the German path to reconciliation is of less interest than the outcome. Conversely, Japan's multifaceted experience with transitional justice, as well as memory, not focused on criminal responsibility, is deemed irrelevant to the German case, which in Germany tends to be treated with a similar claim to uniqueness as the Holocaust. The comparative approach is therefore central to my use of the term loser's justice. So what is it? It is tempting to understand loser's justice as essentially the political use of the victor's justice argument, namely the rhetorical pushback against the trial's legitimacy. I'm not going there. John Dower used the term as well, actually, in his Embracing Defeat, to point to the ways in which Japanese assisted the Allies in identifying perpetrators, in effect, the ways in which Japanese civilians pointed fingers at each other. That's an interesting historical fact, but also not my concern here. Neither is it useful to ignore justice and immediately jump to memory, as we habitually do when we speak as if the victors, as victims, have justice, and the losers, as perpetrators, have memory. From the perspective of the divide between German and Japanese memory, as we have come to know it since the 90s, the social history of bringing the Allied program to an end in the 1950s can safely be ignored in Germany and appears as an unsurprising truism in Japan. So I want to turn that around a little bit. In contrast, I use the term loser's justice to explore how the victor's politics of the past, which itself is Norbert Frey's term, that means the victors that turned into occupiers, that turned into allies, how those politics of the past refracted social relations in perpetrator societies struggling to regain both internal cohesion and external credibility. It brings into view precisely the aspects of the trials that are typically left out. The faceless multitude of so-called ordinary war criminals, in other words, not the ones that were judged in Nuremberg and Tokyo, and in Japan convicted in hundreds of military courts across Asia and Europe, rather than the handful of infamous wartime leaders tried in Nuremberg and Tokyo. The treatment and rights of convicted war criminals serving sentences in prisons, playing into the contemporary human rights debate, and the post-trial negotiations of clemency, release, and reintegration that Sandra talked about, which were more slippery and less glamorous than waging the law in the courtroom. The crucial space for this, both real and rhetoric, was the prison, and I would argue in particular the American prison for war criminals, Sugamo in Tokyo and Landsberg am Lech, not very far from here. I know this sounds too US-centric, but there are historical reasons for this. This is not just because I have an American sort of blind spot, and we can talk about that a little later. Unsurprisingly, the ways in which the treatment of those serving sentences in American-run prisons on German and Japanese soil changed over time, closely paralleled the changing quality of the occupation and the transition to alliance in general. The American military gave Germans more and more responsibility over their own affairs, allowing, for example, for German co-participation on the US clemency and parole boards. This was not granted to the Japanese, that assessed the reduction of sentences. In Japan, a paternalistic friendship developed between the American occupiers and the Japanese as they embraced defeat, as Dower says. This made for an astonishingly rich and amicable cultural life in Sugamo prison, but did not give Japanese officials a say in the modification of sentences. As it was, convicted war criminals were only one group of people among several towards whom the American and other occupation forces made social policy. But they mattered, so for example, from war widows to displaced or stateless persons, to landlords and big business. These wider social contexts were rarely considered from the perspective of Allied transitional justice, but they matter tremendously to the perception of the war criminals problem and in the reconstructing societies at that time. So I understand losers' justice as the ways in which Japanese and Germans came to take ownership of the Allied program, even as they were powerless to effect the sentences themselves. This was achieved in remarkably similar fashion in both countries, namely through the mobilization of democratic politics, through social legislation, and through transnational activism that pointed out the inequities produced by the geographical spread and immense diversity of Allied justice, certainly in Asia, but more importantly, capitalized on emerging opportunities of global human rights demands and Cold War rivalries. I employ here Masuda's argument of looking at the Cold War as social history. And his argument is precisely to see the opportunities that the Cold War afforded all sorts of people who then used that as a context to further their own interests, rather than the Cold War imposing particular needs that everybody then kowtowed to. So it's a much more, it's taking the Cold War context seriously, but looking at it from an almost activist, how people actively used it rather than how they were sort of conditioned to look at the world. The justice part refers to this history, which Liz Borgward has so admirably written about. How the war criminals issue factored into this context is much more productive if seen comparatively, both in terms of domestic social policy and in terms of the place of Germany and Japan in the emerging post-war international order. I will say that the US was central here, and much more to the Japanese case than the German, because of Germany's integration into Western Europe. You can tell that there is a lot of stuff that needs to be opened up to really develop this idea. Let me say in conclusion that the very parallel, even I would say very similar stories that I see here in terms of social integration and the ways in which the war criminals problem was factored into a larger issue of social integration and rehabilitation, nonetheless operated in a very, very different context. And this has in part to do with the fact that the German government actually took, as developing an identity of the social welfare state, took a much more proactive role in making social policy to a number of victims groups. So compensation and reparations were a much larger deal for the German government, whereas the Japanese government in many ways stepped back from that. And every inch of compensation and of goodies that any victims group got in Japan was bit by bit fought for from the ground up, and the war criminals were part of that. This has implications for the 1960s, I believe, when the two countries go, really grow apart. One picks up war crimes trials on its own, with its own laws. The other one never again touches it. I think that these are different reactions, or they are actually the same type of reaction, but they look completely different. And I think that the 1950s help us understand why that divergence is actually also rather similar. So there's a big thing here that one can develop that my argument in the end leads to. But I'd like to leave it here and hope that I gave you enough to go by. So thank you very much.
Well, thank you very much. With that by Dr. Franziska SERAPHIM. So all the four panelists will finish their presentation. And of course, where you all agree that really the content on the basic elements for discussion are really very rich. Where from the presentation you heard what happened where after the judgment. It's not only about the legal background, but also about the political situation globally, which changed dramatically after the delivery of the judgment, especially about the Treaty of 1952. And also we heard the views on His Excellency Judge Webb. And for me, actually, when I read the material, me personally, I showed great respect for him. I think really I respect him. Nothing but the judgment were 1,218 pages, and it took him to read the judgment for 8 days, from the 4th of November to the 12th of November. And also in all his career as judge in 24 years, it was the first time for him to announce the death sentence. And death sentence not only upon one person, but upon the 7 persons. Anyway, I respect His Excellency Judge Webb very much. And also we heard about the trial in Khabarovsk, where after the Tokyo trial, where this is very, limited. It's about biological warfare. And of course, where it's very important, it's something which was missed in the Tokyo trial from the 3rd May of 1946 until the November of 1948. So really, this is something. And this trial was concerned with 12 accused. And also, lastly, we also heard the views about the losers' justice. Well, since time is really limited, so I don't want to waste too much time by. So simply, I open the floor to see already hands, so we can see. Yes, so many, I don't know where. And this is the first. Yeah.
Yes, I'm Philip Austin from Keio University in Tokyo. Many thanks to all of the panelists for introducing inspiring new elements into the discussion. And I have a few questions relating to the first presentation made by Professor Wilson. And I'm very thankful for your presentation and on how clemency was granted to the persons convicted at the IMTFE. And while doing so, you repeatedly also referred to some parallels in the treatment of the convicted German war criminals. And with all respect to these parallels, I would like to make a slight objection because what you said is probably correct with regards to the lower-ranking war criminals which were not convicted in Nuremberg, or maybe in the subsequent trials of Nuremberg, but especially in the other occupation zones and in and by court martials and war tribunals conducted by the Americans or the British or the French. But this does not apply to the persons who were convicted by the IMT in Nuremberg. You mentioned that in Tokyo, in the case of Tokyo, all persons who were convicted were, at the latest until the year 1956, set free again, which is absolutely true. But in the case of the German criminals convicted by the IMT, the sentences were actually executed as they were handed down, with very few exceptions. And you might know that in Spandau, near Berlin, it was Rudolf Hess who was held there until 1987. So this is one big difference, actually. And in this context, talking about societal or historical backgrounds or contexts, it should also be perhaps mentioned that the most striking difference, actually, is what happened after that, after these prisoners were released. With which I would like to say that while in the case of Japan, as is widely known, or let me start with Germany. In Germany, the major war criminals convicted at Nuremberg by the IMT were not able to return to elevated or prominent positions in society later on. And in the case of Japan, it should be noted that some of those convicted by the IMTFE took on leading positions in society, especially in Japanese politics. They were politically rehabilitated, and some of them, like Shigemitsu, became the foreign minister, and another one, Kaya Okinori, who was also convicted in Tokyo, he became minister of, this is quite ironic, Minister of Justice in Japan later on. And I think this is the most striking difference in terms of how the societies reacted to the convictions at Tokyo and Nuremberg. Thank you very much. If I may have just one more second, another question, a very simple question to Dr. Polonina. Thank you very much for your comments on the Khabarovsk trial. I actually also did a short piece of paper which will be published in this summer in this regard, and I had a lot of difficulties trying to get hold of the 1943 Soviet decree you mentioned. I couldn't find it, actually. And if you have it, please give me a copy. That's my first. Because I still do not know what actually was the legal basis for the establishment and the conviction of the accused at Khabarovsk. And you, if I understood you correctly, you mentioned that they pleaded guilty to charges relating to crimes against humanity. Well, as you might know, at that time, and especially now, if you have a look at the Rome Statute, such human experiments could be qualified as war crimes or as crimes against humanity, and it would be very interesting to find out if such a precedent was already occurring in Khabarovsk. Thank you.
Well, could we just group a few questions and then we'll let the panelists will answer? And I think when the second one is, yes, okay, yeah.
Only very shortly, because I think Philip Austin already asked a question, which I wanted to. But to Franziska SERAPHIM, I mean, you mentioned this divergence between Japan and Germany. To what extent do you think was this a difference also related to difference of occupational policies or occupational durance, how long it was? I mean, Germany was longer under occupation than Japan.
Yeah, the third one, yeah. I just try to remember the order.
Thank you so much for 4 really wonderful presentations. I have a question that probably touches on all of your presentations, given the title, and anyone's welcome to respond. I detected some sympathy to the notion of clemency, but I may or may not be reading that right. And I guess that's my question. Is there anything we can say normative or ethical about some of these post-judgment responses? I mean, it has always struck me as a conundrum of this period that We have these opening speeches on these trials. These are the symbols of the essence of evil. I know Don Franz could quote it correctly. They are, evil incarnate is effectively what we're hearing over and over again. And even in some of the subsequent Nuremberg trials, there are still, still death sentences coming out. But it seems that in large part, with a few exceptions like Rudolf Hess, if you didn't get executed right after the trial, you were out by 1960. And given, or even certainly by about 1955, everyone is out, right? And there are varying views about that. Certainly Nuremberg prosecutors were outraged. That was the word they used at the McCloy clemencies. But beyond what people thought, is there anything we can say normatively, ethically, in the sense of international criminal law and justice, exactly what we're doing if we're demonizing in 1945 and saying never mind in 1955? I just don't know how to process that, and I wonder if any of you has thought about that.
Yeah, and then we take last one. Yeah, Professor Totani.
Thank you. I have a question for Ms. Polonina, but before I ask my question, I'd like to second Professor Zhu on your comment on Justice Webb. I'd like to point out that Webb, who did reach the same conclusion as the majority, reached that same conclusion with entirely different reasoning. And so I would assume that he had a very strong opinion against the majority opinion, but regardless of the fact, he spent nearly a week reading the entirety of the judgment himself, rather than, instead of dividing the reading among the judges. This makes me wonder what kind of state of mind he was as he was doing it. Was he trying to give the tribunal some semblance of unity by doing so, and trying to take some ownership of this judgment, although he did disagree with it. So this is something for future discussion. My question for Ms. Polonina was, could you comment on the Khabarovsk trials findings on the culpability of the emperor and how the findings that presumably give the basis for served as the basis for the Soviet government to advocate the establishment of a new tribunal for the prosecution of the emperor, Japanese emperor.
Thank you for the question. So we have from the audience two professors who asked, four professors who asked 5 questions. And I just open, and then we'll let the panelists to see. And we start from Professor Sandra Wilson, and then Dr. Naria Maurice, and then Dr. Franziska SERAPHIM, and then Dr. Just this order. Yes, so please.
Thank you for the questions, and thank you, Philip, for the correction. Yes, I forgot to mention Spandau. I think it was the pressure of the 10 minutes. But of course, the Spandau 4 by the end of the 1950s stayed there. And yes, that is a very interesting phenomenon about the social and political positions that the Japanese former war criminals versus the German former war criminals were able to take up. The standout example on the Japanese side is Shigemitsu Mamoru, the one who got 7 years and got paroled by the Americans. He'd already been foreign minister 3 times. He became foreign minister for the 4th time in, I think, December 1954. And he plays a really interesting role as part of an elite pressure group that is going around talking, as foreign minister, obviously talking to high-level officials of the former Allied countries, saying, well, I'm a former war criminal. He wasn't remotely embarrassed about it. And this issue is really personal for me, and I think you should let them out. And by the way, the communists are sending home the Chinese and the Russians and the Chinese are sending Japanese war criminals home, and it looks like the communist countries are more lenient than the capitalist countries, and don't you think this is an embarrassing thing? And so He does a lot of that work, as does Kishi Nobusuke, who was not convicted or charged but had been imprisoned as a suspect, as do several other people. They form, I think, the public campaign that we heard about from B is not so vocal on the subject of the Tokyo defendants because of that line of argument that says ordinary war criminals good, convicted leaders bad. But at the elite level, there were people who were very effectively able to argue for the freeing of war criminals. Yes, you probably did detect a sympathy for clemency. My personal view is that there is no use in holding grudges forever. I don't know how to express that in academic, ethical terms, but I think that it's probably a more productive way than maintaining rage forever. What does it mean that they were all let out so soon after huge outrage? I find it fascinating that when you read the rhetoric of the trials to think how soon they were out. I think it means that the world changes. Politics changes, global imperatives change, and that's why, one of the many reasons why politics is so important to this story.
Thank you. Just now I forgot to say, actually, I noticed the time is really limited. So I wish that the reply to the questions will be as short as possible. Yeah, thank you.
Thank you very much, Yuma, for the question. I think he was crazy personally to want to read something for 8 days, but perhaps he was not quite aware of how long it would take. But I think it showed a number of things. And firstly, obviously, continuity, because really, unless he had been absent and somebody else was in the president's chair, he was the voice of the bench. That is just a matter of fact. But it also showed, I think, judicial, or at least it gave the semblance of judicial unity. You would all know probably that the separate and dissenting opinions were not read from the bench. So by reading only the majority judgment, perhaps it gave this impression that it was the judgment of the bench. And I think if he had decided to share the duty, it would have been rather awkward to have selectively chosen judges to take turns. And if everybody had spoken, it would have become inescapable that both Justices Bernard and Zaryanov could not probably read the judgment in English. So also to preserve a bit of judicial dignity and to avoid embarrassing them as well, perhaps, is a reason. So, but I can't imagine it was a very fun job, because I've given several lectures in a row, and who would want to read for 6 hours a day for 8 days straight?
Okay, thank you.
Professor Zachman's question about the divergence being related to the length or the different lengths of occupation policy. There are many different reasons that come together, but I don't think that that's particularly informative, let's put it that way. Yes, there were some differences, but I mean, the big turning point comes in Germany in 49 and in Japan in 52. Yes, the length was there. There is some value to it, but I think other reasons are just so much bigger, and I mean by divergence really the early 60s or late 50s, when Germany picks up war crimes trials as a tool, and Japan doesn't. And I think it's both reactions to especially the Americans. I think US policy is crucially important to all of this, or rather the ways in which these two countries related to their new allies. And the fact that Germany was by then well on its way to be integrated into Western Europe within an East-West context, and the fact that Japan really was separated from Asia and was, I don't want to dramatize it too much, but kind of at the beck and call of the US, if you want to overstate the case a little bit, really colored that very much. I think that both responses in the early 60s actually are responses to the ways in which the Allies, and especially the US, had handled the war crimes program. But there are a variety of things that come together, and Judge Palangant comment yesterday, I believe, is really well taken and is something that I constantly think about, and that has to do with the place of the law in Asia. I think that you really have a point, but I just don't yet know how to evaluate that, because clearly, as you have shown, Professor Zachman, the Japanese had international lawyers and thought about trials themselves. They didn't need the Western powers for that. And at the same time, it does have a different place. And the fact that all Asian nations, many of them had collaborator trials, so clearly trials were on the horizon. But the fact that it was not, that this particular past was not taken on in the same way as it was in Europe after the Allied trials does make you think. It's just that when you put the question this way, it's a really slippery slope into Orientalism, and that's why I'm very hesitant to go too fast in that direction. But I wanted to say a couple things to Professor Aman's very potent question. I mean, that's something that we all think about the whole time, and I cannot answer it in the 1 minute that I have. But I wanted to acknowledge it and to maybe push back a little bit in the sense that if we make this kind of opposition between you either for or against, you're either about the evil or you kind of nullify it, that's not helpful. We've got to, that's why I look at this history as a social history. We've got to see it from another, and it's not about good or bad. I think we need to get beyond that.
Yeah, with regard to the decree, yes, I have the text, and it's a little bit difficult to find it unless you speak Russian, and can look in like strange Russian sources. But it was published like in Russia, but this publication is not very wide, it's not really available, so I found it just a copy on the internet, but yeah, I have it. So, and it's very interesting why they decided to use this decree, actually, because they, after Tokyo and Nuremberg, and after so much had happened in the field of international criminal law, because this decree refers only to access war criminals and local collaborators, and also it contains references only to murder and torture of Soviet POWs and civilians, treason, brutalities and atrocities. So none of this really applies to the Japanese defendants. That's why it was so important. The prosecutor in Khabarovsk had a really important role to justify and to address these issues, and I mentioned it in my presentations, the way he did it. Charges against humanity. The indictment didn't contain any references to the charges against humanity, and why it's so interesting, then the defense lawyers jumped in and supported the prosecutor and said that, yes, some of my clients actually had committed crimes against humanity. And for me, it's really it's unprecedented that Japanese defendants themselves admitted in the proceeding that they had committed crimes, and crimes against humanity precisely. And I think that it was not by chance that they spoke suddenly about the crimes against humanity, and as I mentioned it later, the Soviet Union really hoped to organize a subsequent trial like it was done in the case of the Nuremberg Trials, when 12 subsequent trials took place, and I think the Soviet Union still had hope that they would be able, if there were any trials, that they would be able to influence them. So then the question about this evil and then the fate of the defendants, this conflict between the rhetoric in the courtroom and then early release. In the case of the Soviet Union, in the case of the Khabarovsk trial, it's really remarkable because all these people were released by 1956, and most of them, with the exception of Yamada, who was sent to China and was held in Fushun prison, all of them were sent to Japan, and even they were given nice clothes, and they even were sent to Moscow and were given a tour there. So they were treated as guests and not as defendants. And if you read the trial proceedings, they described as devils, and their crimes were hideous. And culpability of emperor. Yes, it was mentioned that he signed the document that established Unit 731, which was known as Water Purification Unit officially, that he approved vast financial support for this program, and that members of the imperial family visited the facility in Pinfan on numerous occasions. So the idea was that he must have known what was going on. Yes, basically, in short, when I describe it shortly. Thank you.
Thank you. Yeah, with all that, where at first where I said that each of the panelists will make the concluding remark, and then where actually where I have to say that I'm the first moderator where in this session so far who did not control the timing. And yeah, with some minutes passed. But it's no doubt where all the four eminent panelists that did really very well. And also for me, before leaving, I must say, as I said before, that I'm really grateful to the organizer for this conference, in these 2 days where you can see we discussed so many issues. We discussed, debated about the substance, the merits, the crimes, where we also discussed and debated on the procedure issues, fair or not fair. And for me, I think it's okay if we have different views and if we do not agree to each other. But however, for international justice, what I'm afraid the most is ignorance. That means when the Tokyo trial was there, it took place 17 years ago, and it will be the most terrible that if people reacted in such a way as if nothing happened. And this will be, for me, the most terrible. And from this aspect, I must say that I feel that the International Nuremberg Principal Academy really does something as great contribution to the promotion of international criminal law. And for that, we are all very grateful. And with that, I just finish my role as moderator, the failed moderator, and also thank all my panelists for their wonderful presentation. And with all that, I also thank you, the audience, for your patience and also your cooperation. Thank you very much.